Representative Bourne.
Thank you, Madam Chairman. It's a great follow-up from the last speaker. To be clear, a question for the sponsor. In the case, we've heard this many times, in the case that Roe v. Wade were overturned tomorrow, abortion in all instances until viability, and abortion post-viability for life and health of the mother is still legal in Illinois if this is passed or not, correct?
All of those rights are at risk once Roe falls. All of the enjoined acts in our statutes would be subject to litigation and potential reviving.
I'm not talking about enjoined acts. I'm talking about legal abortion, right? Trigger language already repealed under House Bill 40.
There's criminal penalties for physicians performing those abortions in our statutes.
Abortion
legal or
is
not,
still
there's
legal,
penalties there
that are currently enjoined.
and could be very easily lifted.
I highly doubt that. I know that we have very different thoughts on where this bill needs to go, but in the interest of a committee, I think it's very important that we dig into the language of the bill and get to the intention of it, because I have some questions about getting into the weeds. So I will not be worried about the interest of time. I have quite a few questions. The first one, what is your definition of a fundamental right?
Sorry, I wanted to check if that was actually just a phrase or a legal phrase, and it actually is, which refers to that person's ability to make decisions about things like religion and healthcare and self-determination.
Right, so I mean, other fundamental rights in law are equality, freedom. They're subject to strict scrutiny in judicial cases. So we are adding abortion to the list of fundamental rights like equality and freedom in our laws. Is that correct?
I believe that we are enforcing a woman's right to self-determination.
What does it mean if we change the current law so that an unborn baby has no independent rights? I think this gets to a question that Representative Bailey was asking. No independent rights, does that trump the fact that if an unborn baby were killed, homicide, unintentionally, they have no independent rights under the law?
Representative Cassidy has asked that I take this question. The Reproductive Health Act does not strip the state of its ability to take action if there has been a situation as specified in the intentional homicide, the involuntary manslaughter, the voluntary manslaughter provisions that allow the state to prosecute someone if that person attacks a pregnant woman and harms not only the pregnant woman, but also the fetus that she is carrying. Likewise, the Reproductive Health Act leaves in place Illinois' Wrongful Death Act, which allows usually the expectant parents to bring a wrongful death action in the case that a third party, by which I mean not the pregnant woman, tortfeasor, attacks or causes some kind of negligent action which injures the pregnant woman and the unborn and the fetus. What is really essential to note is that current Illinois law, namely these criminal penalties and the Wrongful Death Act, are very explicit in saying that they do not apply in the context of health care, including abortion. And so the Reproductive Health Act leaves these provisions in place. In addition, the Reproductive Health Act is consistent with Illinois decisional law, including the Supreme Court of Illinois' decision in 1988 of Stallman versus Youngquist, in which the Supreme Court declined to allow a child to sue her mother for acts that happened when the woman was pregnant with this young woman and that caused injury in utero to this child. And the Illinois Supreme Court wisely recognized that if it were to allow a child to sue his or her mother for acts that caused harm in utero, that the Supreme Court would be creating a legally untenable situation in which the pregnant woman and the fetus were legal adversaries from the moment of conception until the moment of birth. And that, quite frankly, said the Supreme Court, would be just an untenable situation in which the pregnant woman, really, would essentially not be able to make, really any decisions during her pregnancy. And so the Reproductive Health Act leaves in place very important protections in the Wrongful Death Act and in the criminal law.
It leaves protections in there, I know, but it also says they have no independent rights. Is there any other case in our law where someone who has no rights could have a criminal penalty for harming them? I mean, how do you recognize in statute, one, that an unborn baby can be killed and there can be criminal penalties for that, yet they have no independent rights? Does that not seem like
actually, it's very
difficult to reconcile to you?
No, it's actually very consistent with what has been the progress of the common law, quite frankly, for decades. And basically what, the courts have recognized is the loss expectancy interest of the pregnant woman and the harm that was really, initially inflicted on the pregnant woman. So I think that this again is, the Reproductive Health Act leaves these provisions intact.
Okay. Could you expand on, this is one of the new provisions of the bill, could you expand on the life and health of the mother? This seems much more expansive than the current definition, so I have some specific questions. One, it gives a list. Health of the patient, all factors that are relevant to the patient's health and well-being, including, but not limited to, physical, emotional, psychological, and familial health and age. When you say but not limited to, what else are you opening this up to? What are you envisioning this includes?
Representative, that language comes directly from the Supreme Court's 1973 decision in Doe versus Bolton, in which the court defined health to include but not be limited to the factors that you laid out. This definition of health, this broad definition of health. So if it's been in place since 73, what else has it not been limited to, other than these factors? It basically recognizes that the decision about health can involve a multitude of factors that have to be based on essentially the case before the doctor at that point in time. And this is very consistent with medical standards.
Yes, but I'm asking for specifics, right? You're saying this language has been in place since 1973. Certainly there must be cases where these factors were not included and there was something that was not limited to, right? A specific case where a woman went in, it was the health of the mother, not limited to these specific factors. Can you give me any other factor that has been included?
No, I think that I cannot. I cannot. I think that it's a very broad definition of health.
Very broad, extremely broad.
And it was appropriately broad because I think as again, the Illinois courts have recognized in a couple of cases, including N. Ray Baby Boy Doe and N. Ray Baby Boy Brown, that a pregnant woman's health has to be the priority of the physician during pregnancy. I mean, that is the standard of care. That's the standard of care that we all expect when we go in and seek medical care. We want the doctor to look at us as an individual patient and take into consideration the health.
Not just health. This definition is well-being. That seems overly broad to me, right? You can imagine a number of cases where a doctor, let's say someone goes in to have an abortion, the doctor is determining, is your health and well-being at risk? That seems to go way beyond a medical scope to me. Is that what you've seen in practice? It could be financial well-being, it can be...
I don't ask my patient why they're having an abortion. It doesn't matter.
Even if the baby is viable, you have to.
In Illinois, I don't perform abortions after viability, so no, I don't ask.
But it's legal to receive an abortion
Not after viability.
post-viability if the life and health of the mother is at risk.
In Illinois, I don't perform abortions post-viability, number one. When they are done post-viability, it's truly for the health, like a patient who's crashing. I mean, we take that very seriously. If
A
it is
patient who's crashing how?
like
Health and
dying,
well-being.
it's truly done when someone is dying. That is when it happens, post-viability.
We are talking about instances where you have to ask the patient, right? We are talking
That
about
doesn't happen
post-viability.
post-viability. Post-viability abortions happen when the patient is dying. They have cancer. The pregnancy is going to kill them if they don't get treatment for their cancer.
Under current
Representative-
statute, I'm asking in
Representative
practice.
Bourne, there are other people who would like to speak as well, and please
No,
don't interrupt
this is a
the...
very important bill. I'm trying to get to the point so that we are not stalling further.
Keep asking the same point, and they keep answering you, and you don't like their answers.
They're
So
talking
it's-
under current statute. In practice, with this new definition of health of the patient, this is talking about post-viability abortions.
And I'm telling you the answer. Doctors are not going to be performing abortions post-viability unless the patient is dying.
But that's not what this legislation says.
And
This
I'm giving you the
legislation-
answer of what doctors are going to do. Doctors are not going to be performing abortions just willy-nilly.
Then let
It
me
is
ask
going
you-
to be because their patient is dying.
Then let me ask you in practice, does this, if you are given this definition,
My practice
Of
in
health of
medicine
the
is not going to
patient.
change based on legislation. It never has, it never will.
I would hope that your practice changes based on legislation and what's allowed and what's not allowed. But if you were given this definition, as an abortion provider who is looking at a post-viability abortion, and your scrutiny has to be on the health of the patient, and it says, a patient's health and well-being, including, but not limited to, physical, emotional, psychological, and familial health and age, you cannot tell me that that only includes patients who are in the act of dying.
I don't know how to answer your question any differently.
Okay. I think we've established that this is much broader than just a patient who is dying. Health and well-being, including but not limited to physical, emotional, psychological, and familial health and age. That was my next question. What does familial health mean? Is that outside of the mother and her baby? Is that other children, spouse? What does familial health mean?
Representative, this standard, and again, I want to go back and say, it's been upheld by the Supreme Court in 1973. It was upheld again a few years later in the Colati versus Franklin case, 1979. Basically says that we are going to trust physicians to make the decisions based on the individual case before them to best protect their patient's health. That is what we want physicians to do. That is what physicians do all the time. This standard in terms of allowing abortions after viability only if necessary to protect the health or life of the pregnant woman is almost identical to the standard that is in current Illinois law, Section 5.1 of the Illinois abortion law, which says after viability, no abortion can be performed unless it's necessary to save the health or life of the pregnant woman.
I
Okay,
understand what it currently says.
Do you have further questions?
What does I have a lot more questions, which I said at the beginning. What is familial health? I'm asking, what is familial health? Does that just include the mother and her
We're not gonna be
unborn
here all
child?
night.
Or does it extend to other family members?
I do not know what the Supreme Court had in mind when they
Okay.
used that term.
Okay, well, I think it's important before we put it on our statute, we know what it means. Moving on to,
Bourne, you have one more question, and then we're moving on to the next person.
I would contend that I have
You may,
30 more questions on the text of the bill. We are talking about over 100 pages of a bill that we saw less than 3 hours ago. We have questions about what this means being put in statute. Committee work is where we get into the meat of the bill. It's where we get our questions answered.
the language of this bill has been out for many, many months.
Actually,
this is a
the
small
definition-
amendment to it.
the
There have been a
definition we were
number of
just-
changes,
The
not very
definition we were
many.
just talking about came out
30
in
of those
this
questions,
amendment.
probably 28 of those questions were on the basis of the bill that has been out there for months.
That is on the new definition of the life and health of the mother, which was not included in the previous bill. Another change, this is my next question, another change.
It's not going to be 30, I'm telling you that right now. So why don't you pick your top 3?
I'll ask compound questions then. I've got a question about reporting. We heard earlier that currently we don't know why these abortions were necessary. We don't have any statistics about what was essential for the life and health of the mother, what was a question that we often have on the exemptions of rape and incest, what percentage of abortions really, what percentage of abortions would include those exemptions. I've seen FOIA exemptions in this bill. What will the public be able to know about abortions performed in Illinois if this law were passed?
To the first half of your question, 91% of abortions were performed before the 13th week of pregnancy. So we're talking about much, much earlier. In terms of the reporting, it's not a question that we ask. We don't ask why. It's just not, frankly, why I had my abortion is none of your business.
I'm not asking to expand the reporting requirements. I just saw FOIA exemptions in this bill.
There are FOIA exemptions in many Illinois laws to protect very important privacy rights of people. There are FOIA exemptions to protect law enforcement sources. There are FOIA exemptions to protect state and national security. FOIA exemptions are very common in public health reporting statutes, and what the RHA does is essentially assign to the Illinois Department of Public Health, as is the case in other public health reporting, the obligation to determine what kind of reporting is essential for the Department of Public Health to collect important public health data.
So I still haven't gotten a direct answer. If we FOIA how many abortions
That's
were
2.
performed in Illinois.
Is that your second question now?
No, I'm trying to get the answer to my original question with what information will be reported. Is it the number? Is it the age of the women who went in to get an abortion? We're able to get that information now. Will we be able to get that information after this law is passed?
Yes, because that information is reported annually by the Department of Public Health. It is not something that is reported only because of FOIA.
Okay. Colleen, try to keep your answers short as well.
As I was reading through the bill on the floor this afternoon, what oversight or standards are going to be there for abortion facilities by taking abortion procedures out of licensed ambulatory surgical treatment centers?
Those provisions have not been applicable to abortion providers since the 1985 decision in Ragsdale. The Reproductive Health Act will treat abortion providers just like other healthcare providers who are subject to appropriate public health and licensing requirements.
Your last question.
With the chair's indulgence, I have 2 more that I have deemed my most important. This one, I think, should be short. Currently in statute, we prohibit sex-selective abortions. The injunction that was placed on that was only for criminal liability for physicians. Yet in this bill, you are repealing the prohibition of sex-selective abortions. Can you explain why?
That whole injunction is repealed, but frankly, that would fall under the medical standards of care that that will apply to all of that decision-making between a patient and a physician.
Okay, my last one. Can you explain, this is, again, the brand new language that we just saw today. This is not something that we have digested over months. This is brand new. Fetal viability, the definition. In a professional judgment of the attending physician, if there is significant likelihood of a fetus's sustained survival outside the uterus without the application of extraordinary medical measures. Could you give me a definition of extraordinary medical measures?
For a fetus, it would depend. Most fetuses early on are going to be intubated. For a fetus, I would not consider that extraordinary. Most are going to be intubated. Depending on where you're at, they might be airlifted to a NICU. That may or may not be considered extraordinary depending on where you're at. If you're 8 hours away, probably extraordinary. If you're in Decatur, coming to Springfield, probably not extraordinary. For some babies, once they're born, you could be talking about multiple surgeries. Antibiotics, not extraordinary, but multiple surgeries, pretty extraordinary. We do some other treatments that are pretty simple, IVs, medications, not very extraordinary, but some of the treatments that we do are pretty extraordinary and painful to keep it simple.
Okay. This is the most concerning piece that I've seen in the bill, and I'll explain it as briefly as possible, but I think it's very important that people understand that this bill contends that it is protecting viable fetuses from an abortion. Yet, a baby is not considered viable if they require extraordinary medical measures, which we just heard could be geographically determinate. So if you live in the most rural part of Illinois, and you know that when that baby is born, they might need to be airlifted to a NICU, which is not next to them at a hospital near them, they could be never determined viable while they are not yet born.
That wouldn't be the only thing. It's all of the factors combined. Because we might not be able to save a baby who's 8 hours away. The baby might not survive 8 hours away from a NICU.
Exactly. So you just said, if you know that this baby, you're seeing them on the ultrasound, they're developing, and then at some point you realize this baby, this pregnancy is high risk, this baby is going to need to go to a NICU. Under this definition, that baby could be determined to never be viable until they are born. When we look at, you were talking about surgeries being extraordinary medical measures. We're looking at, here's the march of dimes, reasons that babies go to the NICU or need surgery. Very simple procedures if they have a heart abnormality. Procedures where they could weigh too much or be growth restricted and they have to go to the NICU. You can see these on an ultrasound.
None of those would be considered extraordinary measures.
A heart surgery? You just said surgery would be extraordinary medical measures.
Did I say all surgeries? I said certain surgeries.
Would closing a hole in a baby's heart be extraordinary medical measures?
Depends on what it is. Some of them, no. Some of them are quite easy.
We are talking about 10 to 15% of babies born in the United States every year require a short stint in the NICU. Under this bill, it is reasonable to believe that that means 10 to 15% of babies before they are born would be considered never
Absolutely
viable.
not. A NICU stay would not mean extraordinary measures. Just being in the NICU is not an extraordinary measure. That's not what I
You said if a
said.
baby had to be flown to the NICU, that could be considered an extraordinary measure. I'm going off of your
I
words.
didn't say just because they had to be flown to the NICU.
Yeah, flying was the key word there. Thank you, Representative.
Flying is the key word.
Representative,
This bill is a gross expansion of post-viability abortions, regardless of how you slice it, regardless of how you define extraordinary medical measures. You've defined it a few different ways. This bill requires much more debate. This bill requires much more digging into. I have probably 20 other questions that I thought would be important to dig into the legislative intent. Some of these provisions are very vague. Some of the things that we are repealing, I think, are being repealed unintentionally and will have negative consequences. And the fact that we are debating this bill on a Sunday night, where the majority of my questions came from the two definitions that we just saw today, less than 3 hours ago, and we're pushing this through, is unconscionable. I'm very disappointed with the process.